Coming up, of the thousands of climate litigation cases filed since the late 80s, 70% were in the past decade.
Those governments are facing court cases because they haven't been acting in line with the science.
We look at a few of the wins and losses of activist movements, from the victorious carbon neutrality Supreme Court ruling in South Korea to disappointment in The Hague over an oil giant's carbon emissions.
Obviously, we're not done with Shell. We're still gonna fight, and there's gonna be lots of activism still.
And the latest and biggest climate case in the world is being litigated in real time.
On the one hand, it touts itself as a human rights leader, a global superpower, and then also a climate leader. But in spaces like this where it matters the most, the US is seriously lagging behind many countries.
But can a classroom of law students take on the planet's most powerful polluters?
This campaign is about bringing dignity to the lives of people that are at the front lines. We're living in a state where human rights is constantly being violated by climate change. That's no way for people to live, and that's no way anyone should live.
Just 2 degrees is on. Now,
the smoke that started this fire did not come from these islands.
the world's biggest legal case is happening at the International Criminal Court. Nearly 100 countries and dozens of international organizations addressed the judges in The Hague in December. Why? Well, it's about the obligations they believe rich countries have with respect to environmental degradation, global warming, pollution, and unsurprisingly, it was young people leading the charge.
Please be seated.
The idea to bring climate litigation to the world's highest court was born in 2019 in a law classroom in Vanuatu, a tiny Pacific island nation where 27 law students lobbied the government to take local fears over rising sea levels to the International Court of Justice.
But the smoke that started this fire did not come from these islands.
We need your help.
We need your help.
We call on the leaders of the Pacific Island Forum
to take climate change and human rights
to the International Court of Justice.
Fast forward to today, nearly 100 countries and dozens of organizations have been delivering testimonies.
Sir, you have the floor.
This advisory opinion represents a historic opportunity for the international community to clarify the obligations of state in addressing this global crisis. For Belize, the stakes could not be higher.
At the heart of the case are legal ramifications for governments if they fail to protect the environment from greenhouse gas emissions now and in the future. Vulnerable nations talked about their crops being destroyed by floods, graveyards being washed away. Emotional pleas were made to protect the environment as well as the ones they love.
These violations are affecting communities and nations right now. We are not discussing future risks or theoretical threats, at least not exclusively. Territories are disappearing, livelihoods are being destroyed, fundamental rights are being violated as we speak.
Countries in Latin America, the Caribbean, and the African continent are also calling on the planet's highest emitters to compensate them financially and cancel their debts.
Developing countries, including SIDS, require up to $584 billion annually by 2030 to address their costed needs and respond to the climate crisis.
Despite these strong pleas, the ICJ's ruling would not be legally binding, but a ruling could help create a roadmap to finally use international law for the benefit of people and nature.
Legal consequences of violations of international law are always twofold. The wrongful conduct, the breaching conduct must cease, it must be put to an end. And secondly, reparations must be made.
But there's been a stark divide in legal arguments made so far. Nations that profit most from fossil fuels say the court has no basis to recommend limits.
International human rights law, however, does not obligate states to mitigate anthropogenic greenhouse gas emissions, nor does it currently provide for a human right to a healthy environment.
The resulting loss and damage cannot be addressed through state responsibility.
Who or what govern rules, international rules, human rights rules on climate change, and how do we get these rules to a point where no one can deny what exists and what needs to be done so that you don't infringe or on anyone's rights or you don't destroy nature?
Many fundamental international human rights treaties were negotiated well before we understood climate change, and certainly well before we had the scientific evidence we have today of the dramatic and widespread human rights impact of climate change. But the point is, even if those international human rights treaties don't mention the word climate change, that doesn't mean that they are not applicable to climate action, and in fact clarify the obligations that states have in that relation. So for instance, a vast majority of states have ratified the Convention on the Rights of the Child. We know that children are the most vulnerable on Earth to climate change impacts because they will be the ones who will bear the impacts for longer. The Committee on the Rights of the Child, which is the expert body that clarifies what the convention means, has indicated that the convention implicitly includes children's right to a healthy environment, including safe climate. So it's basically saying even if the convention doesn't mention climate change, but we know that all children's rights are undermined by climate change, of course we need states to take action that fulfills those requirements that we find in that convention, because we have very clear scientific evidence that our human rights, and in fact, some people's human rights more than others, are negatively impacted by climate change.
How much weight would ICJ advice carry?
This is a question that in a way has marred international climate negotiations for a very long time. But in fact, many other international negotiations at different levels that may have to do with climate, with biodiversity, with ocean, and with human rights. It's really providing an advice and interpretation of applicable international law for everyone, for the whole international community. It will become very difficult for states to argue otherwise.
So what international law here is applicable in this case that will be used by the ICJ to make a ruling?
So that's already a point of contention between states. Almost all high-emitting states have argued that the court should only look at state obligations on climate change, only under the UN Convention on Climate Change and the Paris Agreement. But this is a very restrictive and narrow interpretation, even of general rules of international law. And in fact, all other states, but also the International Tribunal for the Law of the Sea, which already issued an advisory opinion earlier this year on the question of state obligations on climate change, very clearly stated that many other treaties that states have ratified, that they are a party to, are affected by climate change. And for that reason, their obligations need to be understood also in terms of the action needed on climate adaptation and mitigation and climate finance that allows states to take meaningful action that prevents those negative impacts of climate change on a variety of internationally protected values and objectives.
But also, I wonder what exactly these blocks do legally. But do you get the sense, because you sat in these conversations, do you get the sense that they're doing this deliberately to improve all our lives, or this is literally just them postponing?
Last year, we had the highest level of emissions ever. And there is no indication that most states will do enough by 2030 to save all of us for climate chaos. In fact, we have a 40% gap between commitments and the level of commitments needed for us to avoid the 1.5 degree temperature guardrail. It's hard to believe when states argue before the International Court of Justice, you have to trust this process under the Paris Agreement to take care of this. This is where we will find a way that is viable for all the different, very varied members of the international community to cooperate.
So I get the impression that there is hope once we have once we dot our I's and cross our T's looking forward when we approach cases like this. I get the impression that there is hope.
Having the judiciary being able to step in and show where government's conduct is below the standards expected and providing some indications of what action we need, that gives us hope. it's a very difficult balance for courts to show where governments are not doing enough, but how far can they go in saying exactly what they should do? And those specifications are a matter for discussions, within states and among states. States don't have an unlimited margin of discretion. And the more and more we have science showing that we're not doing enough, and the more and more people are more and more severely impacted by climate change, then that margin of discretion becomes much smaller, and the urgency of meaningful action becomes a matter of scrutiny by the judiciary and others.
So for small island states in the Pacific region like Fiji, floods and superstorms are annual threats, but it's rising sea levels that have some people so scared they're digitizing their geography and culture for posterity.
The Pacific is facing an existential threat from the climate crisis. My country, like many others, is facing a future of disappearing under the waves should global warming go beyond 1.5 degrees Celsius. For the last 3 years, I have been working with my colleagues from island nations and with people from all around the world to seek an International Court of Justice advisory opinion on climate change and human rights.
As Pacific Islanders, we have witnessed some of the deadliest impacts of climate crisis. Young people are tired of half-hearted efforts and empty promises. I cannot highlight enough the urgency of the situation that we find ourselves in.
Vishal Prasad is a Fijian climate activist and, along with other campaigners, brought this case to the fore. I called him up in The Hague. This ICJ ruling, whether it comes out, if it comes out in your favor, I don't think it's going to be legally binding. What are you hoping exactly to achieve by going through this process?
With this ICJ, we want to settle some matters of law for good. Look at state obligations under all of international law. So that's looking at under human rights law, that's looking at environment law, the law of the sea, customary international law, all of these sources of law that will provide a more holistic, harmonious understanding of what countries need to do. So when we go to COPs, for example, when people take cases to courts in litigation, wherever they are, you have the security of the world's highest court clarifying as a matter of law specific points that have become deadlocks for now. Things like loss and damage, things like climate finance, the mitigation goal, for example, 1.5. We're not going to hit it at this current track. What does the ICJ advisory opinion, cognizant of that reality, can provide that course correction that's needed so that countries, when we do push them to act using the opinion, we're in a much better place to really get something going.
Talk about this response by the US, of course, to the ICJ case, saying that they have no liability in what's happening in terms of carbon emissions, in terms of climate finance. What does that do to your cause, if anything?
It's sad that the largest historical polluter has not come on board this campaign in a meaningful and robust manner, in a progressive manner that we would have liked it to be. It came with a very disappointing submission that was rooted in trying to limit ambition to just the Paris Agreement. It tried to, as you said, limit climate finance, avoid its historical responsibility, say that human rights is not relevant in discussions around climate change. I mean, all of these are frankly very hypocritical of the US to see. On the one hand, it touts itself as a human rights leader, a global superpower, and then also a climate leader. But in spaces like this where it matters the most, the US is seriously lagging behind many countries in terms of demonstrating the climate leadership in international law that is so desperately needed. But I think the work of the campaign still continues, because this is a request for the clarity of the International Court of Justice. The US is one state in this, but what we have seen in the past days is immense leadership from global South countries that have come in to fill the void of climate leadership that the world is seeing currently. Countries like Vanuatu, many from the Pacific, that have really stood up amidst insurmountable obstacles, really challenging the status quo in many ways and asking for climate justice, asking for reparations and discussions around liability and responsibility.
What do you think is at the core of why countries like the US just refuse to accept this and for all of us as a planet to move forward?
I think it's the power of a specific group of people, fossil fuel industry, the lobby that is so strong. I think they wield a large number of influence among many countries. There is a lot of these remnants of the past that are still continuing and preventing us to move into that just transition into a more green, clean energy space. And I think that's so important for us to talk about, because we've seen the power of the lobby and the fossil fuel industry at COPs, and this has been called out by so many.
When you peer into your future over the next 30 years or so, what do you see?
It's just going to get worse. How do you then live? How do you then plan? How do you then survive? And it's about dignity. I mean, this campaign is about bringing dignity to the lives of people that are at the front lines. We're living in a state where human rights is constantly being violated by climate change. That's no way for people to live, and that's no way anyone should live. And so when I look at 30 years from now, the future is even bleaker if we don't address climate change. We've got 40 villages in Fiji, for example, ready to be relocated because of climate change at present now, 2024. 30 years from now, that number is going to rise exponentially. How many more villages will we see moving? How many more people dislocated in Fiji that used to be living so interconnected, intertwined with their land, with their culture and traditions, and now being foreigners?
Is Fiji going to survive the next 200 years?
Our hope is it does. It will. Some form of it will. We started seeing an erosion of the land. We've started seeing sea level rise hit many villages and communities. So I think some form of it is going to remain. What that looks like is the question. And this campaign and the fight of many Pacific Islanders is trying to protect as much as we can, because the country will remain, our islands will remain, our people will remain. In what shape, form, or place they remain is a question and is something we're fighting for right now.
But climate activists from Friends of the Earth in the Netherlands were left in tears after multinational oil giant Shell won its appeal of a previous ruling requiring it to speed up its efforts to cut carbon. The Hague Appeals Court did say Shell had a responsibility to reduce its greenhouse gases to safeguard people from global warming, but dismissed the 2021 decision that it had to cut emissions by 45% by 2030, including all use of its products.
Ik ben hier echt door geraakt. Dit had het moment moeten zijn waar we echt de doorbraak hadden kunnen realiseren in de strijd tegen gevaarlijke klimaatverandering. Dat is vandaag niet gelukt.
To be honest, I was just really disappointed. Like, I was almost crying, and I was in there in the court. And we were just like, at first it looked really good for us, but then it just went downhill. And there are some points of light, I guess, that the court, they acknowledge that Shell actually has to reduce their emissions. However, we cannot go further with this court case like this. And I don't know, I'm just really disappointed, and I feel like it's a setback for climate action and for all the reductions that are needed.
We're not done with Shell. We're still going to campaign, we're still going to fight, and there's going to be lots of activism still. And if this isn't the way, there will be another way to make them reduce their emissions, I think.
I wanted to get a comment from you on the reactions from the appeals court president, Carla Dustra. Here's what she said at the ruling.
Shell heeft namelijk voor scope 1 en 2 een specifieke reductiedoelstelling vastgesteld die inhoudt dat haar scope 1 en 2 emissies in 2030 met 50% zijn verminderd ten opzichte van 2016. Verder volgt uit de door Shell aangeleverde documenten dat zij in 2023 al een reductie had bewerkstelligd van 31%. Shell doet dus al wat Milieudefensie van haar vordert. De vordering van Milieudefensie ten aanzien van scope 1 en 2 is daarom niet toewijsbaar.
Do you believe Shell actually achieved the 31% reduction? And talk about exactly what you're asking for.
Yeah, I think first of all, it is very important to look at the details here. They are talking about scope 1 and 2 emissions, and that's a very technical term, but that basically means the emissions that are emitted at the production process. So if you look at the at all of the emissions that Shell is responsible for, it's only 5% of the total emissions. So these plans that Shell has to reduce the scope 1 and 2 emissions, to reduce them by 50%, is only applicable to 5% of their total emissions. The other emissions, the scope 3 emissions that are that come from burning their oil and gas, so basically the using the products, that's more than 90% of the emissions that Shell is responsible for, and Shell doesn't have a plan to reduce those.
In a Twitter post, Milieudefensie said, I quote, the judge's ruling means that important parts of the verdict which forced Shell to take more and faster action are lost. Elaborate on that part of it.
Yeah, I think here there are some very positive things in the ruling from the judge, and it's important to point those out. So first of all, the judge did say that Shell has a responsibility to reduce all of its emissions, so also those scope 3, more than 90% of their emissions. And that's a very important breakthrough within climate litigation. And in general, it also shows that companies such as Shell have a responsibility to take when it comes to climate change and to CO2 emissions. But the judge was not able to give Shell a very specific percentage for this due to lack of consensus within the scientific community, according to the judge.
I know you guys plan on taking this to the Supreme Court. Is there time for a consensus on what that figure could look like?
When it comes to this consensus, there will always be discussion within science. That's what we know for sure. So it's more important to look at the responsibilities of the oil and gas sector. We know that they are the biggest emitters in the world. We know that they have a relatively large responsibility when it comes to reducing CO2 emissions. And another thing to point out is that the judge agreed that companies have to respect human rights, and they have a responsibility to protect human rights. And that's something that from which we can also conclude that reducing the emissions is very important and needs to be done quickly.
But it is a different story in South Korea, where legal experts are hailing a landmark ruling by the Supreme Court asking lawyers to revise the nation's 2010 Carbon Neutrality Act to include quantifiable levels for its reduction targets. The act, with a net zero goal by 2050, fails to lay out the numbers for what the cuts should look like, what progress should be made between 2031 and 2049. But the 4-year case was brought by more than 200 plaintiffs, including young activists and even babies, to defend their rights and their future.
So it's a very positive ruling, and it's one of the few we have in Asia specifically that looks at this issue. Many of the cases have been decided in Europe, for example. So with climate litigation, which we look at both in this case, but also globally, it's not the only tool, and it cannot be the only tool that we use to address climate change. And I think this case, you can look at it specifically from the fact that what the court can do and what plaintiffs can ask for is this order that it's not conforming to the Constitution and therefore doesn't protect their rights. It is now up to the state to come forward for the government to bring forward a new plan and a new pathway as to how their rights are going to be secured and how we address climate change. So it's definitely not the silver bullet or the end all, and it's very much the start.
And that's our show. We leave you with images from all over the world reflecting 2024 status as the hottest year on record so far, with far-ranging consequences: heat waves, droughts, floods, landslides, deadly hurricanes, and another tipping point as increased wildfires in the Arctic see the Earth's northern polar region switch from a carbon sink to a carbon source.